Good afternoon, Dr. Saigal. Am I audible to you? Dr. Saigal, welcome.
Sir, your mic is on mute.
Piyush?
Yes, sir.
Piyush?
Yes, sir.
Piyush, please call. Piyush?
Yes, sir.
Piyush, please call. Piyush?
Yes, sir.
Piyush, please call. Saigal sir, good afternoon. You're not audible, sir. Please switch on your mic.
Yes, sir.
Piyush, please call.
Yeah. Is it okay now?
Saigal sir, good afternoon.
Is it okay now?
Yes, sir. Good afternoon to you.
Good afternoon
yes,
to you.
Sir,
You're
yes,
not
audible, sir.
That's great. That's great.
Thank you. Please
for
switch on your
joining.
mic.
Pleasure.
Yes, sir.
Waiting for you.
My pleasure. Tell me when to start. I will start immediately.
Please call. Yes, yes. In the next 2 minutes, we will
Yeah.
start.
Okay. No issue. Is it okay now?
Saigal sir, good afternoon.
Is it okay now?
Yes, sir. Good afternoon to you.
Good afternoon
yes,
to you.
Sir,
You're
yes,
not
audible, sir.
That's great. That's great.
Thank you. Please
for
switch on your
joining.
mic.
Yes, sir.
Waiting for you.
My pleasure. Tell me when to start. I will start immediately.
Please call. Yes, yes. In the next 2 minutes, we will
Yeah.
start.
Okay. No issue. Is it okay now?
Saigal sir, good afternoon.
Is it okay now?
Yes, sir. Good afternoon to you.
Good afternoon
yes,
to you.
Sir,
You're
yes,
not
audible, sir.
That's great. That's great.
Thank you. Please
for
switch on your
joining.
mic.
Yes,
Waiting
sir.
for you.
My place.
Great,
Just because to
great.
start, I will start immediately.
Yes, yes. In the next 2 minutes, we will
Yeah.
start.
Okay. No issue. Is it okay now?
Good afternoon.
Is it okay now?
Yes, sir. Good afternoon to you.
Good afternoon
Yes,
to you.
sir.
You're
Yes, audible, sir.
That's great. That's great.
Thank you
Please
for
switch on
joining.
your mic.
We are
Yes, sir.
waiting for you.
My place. Just
Great,
because to
great.
start, I will start immediately.
Yes, yes. In the next 2 minutes, we will
Yeah.
start.
Okay. No issue. Is it okay now?
Are you there?
Is it okay now?
Yes, sir.
Yes, sir, I'm
Good
there.
afternoon to you.
Good afternoon
Yes,
to you.
sir.
You're
Yes,
not audible, sir.
That's great. That's great.
Thank you
Please
for
switch on
joining.
your mic.
We are
Yes, sir.
waiting
I'm
for
here.
you.
Am I audible?
My place. Just
Great,
because to
great.
start, I will start immediately.
You are expected to present.
Yes, yes. In the next 2 minutes, we will
Yeah.
start.
Okay. No
Listen.
issue. Is it okay
Listen.
now?
Are you there? You are expected.
Is it
to
okay now?
Yes, sir.
Yes, sir, I'm
Good
there.
afternoon
Share
to
the
you.
presentation.
Yes,
Yes, sir.
of
Yes,
audible, sir.
Dr. Saigal.
That's great. That's
Then
great.
he
Thank you for
starts
switch on your
joining.
mic.
He
Yes,
has
sir, I'm
already
here.
shared his
Am I
presentation
audible?
My
to
place. Just
all.
because to start, I will start immediately.
Yes, sir.
You are
Okay.
expected to
Yes,
present.
sir. In the next
expected
2 minutes, we
to
will
Yeah.
start.
Okay. No
Listen.
issue.
Move to the
Is it
next
okay
side
now?
when he
Are you
demands
there?
for the
You are expected.
Is it
to-
okay now?
Okay,
Yes,
sir.
sir.
Yes, sir, I'm
Good
there.
afternoon
Share
to
the
you.
presentation
Yes,
to you.
sir.
of
Yes,
audible,
Yes, sir.
Dr.
Okay.
Saigal.
That's great. That's
Then
great.
he
Thank you for
starts
switch on
joining.
your mic.
He
Yes,
has
sir, I'm
already
here.
shared his
Am I
presentation
audible?
My
to
place. Just
all.
because to start, I will start immediately.
Yes, sir.
You are
Okay.
expected to
Should I
Yes,
start?
sir. In the next
expected
2 minutes, we will
Yeah.
start.
Okay. No
Listen.
issue.
Move to the
Is it
next
okay
side
now?
when he
Are you
demands
there?
for the
You are
Yeah.
expected.
Is it
to-
okay now?
Okay,
Yes,
sir.
sir.
Yes, sir, I'm
Good
there.
afternoon
Share
to
the
you.
presentation.
Yes,
to you.
sir.
of
Yes,
audible,
Yes,
Dr.
sir. Okay.
Saigal.
That's great. That's
Then he
great.
Thank you
starts
for switch on your
joining.
mic.
Welcome everybody. He
Yes,
has
sir, I'm
already
here.
shared his
Am I
presentation
audible?
My
to
place. Just
all.
because to start, I will start
The
immediately.
opening remarks
Yes,
will
sir.
be
You
given
are
by
expected
one
to
of the
Should I
yes,
start?
sir. In the next
expected
2 minutes, we will
Yeah.
start.
Okay. No
Listen.
issue.
Move to the
Is it
next
okay
side
now?
when he demands
there.
for the
You are
Yeah.
expected.
Is it
to-
okay now?
Okay,
Yes,
sir.
sir.
Yes, sir, I'm
Good
there.
afternoon.
Share
Dr.
the
Good
Saigal.
afternoon
Yes,
to you.
sir. Yes,
audible,
Yes, sir.
Dr.
Okay.
Saigal.
That's great. That's
Then
great.
he starts
for switch on
joining.
your mic.
Welcome
A warm
everybody.
welcome.
He
Yes,
has
sir, I'm
already
here.
shared his
Am I
presentation
audible?
My
to
place. Just
all.
because to
National
start, I will
level
start
the
immediately.
opening remarks
Yes,
will
sir.
be
You
given
are
by
expected
one
to
of the yes,
present.
sir. In the next
expected
2 minutes, we will
Yeah.
start.
Okay. No
Listen.
issue.
Move to the
Is it
next
okay
side
now?
when he demands for the
You are
inputs from.
Is it okay now?
Okay,
One
sir.
of the
Yes, sir, I'm there.
shared the
Good
presentation.
afternoon
Yes,
to you.
sir. Yes,
Yes, sir,
Dr.
okay.
Saigal.
That's great.
He
That's
will
great.
be starts
switch on
joining
your
us.
mic.
The
A warm
IPR.
welcome.
He
Yes,
has
sir, I'm
already
here.
shared his
IPR
presentation
schedule
My
to
place.
all.
Just because to start, I will start
The
immediately.
opening remarks
Yes,
will
sir.
be given by
Okay.
one of the
Should I
yes,
start?
sir. In the next
The relevant
minutes,
he
we
has
will
also
start.
Okay. No
completed
issue.
the
Is it okay now?
when he demands for the
Yeah.
program from
Is it okay now?
Yes, sir.
Yes, sir, I'm there.
Shared the
Good
presentation.
afternoon to you.
Yes, sir, okay.
Saigal.
That's great.
He
That's
will
great.
be starts
Okay.
joining us. The IPR.
Yes, sir, I'm
Already
here.
shared his program
I'm audible.
My place. Just because to start, I will start
he
immediately.
has
Yes,
started
sir.
sharing the
Okay.
IPR and
Should I
innovation.
start?
In the next
Session-6
he has also
Okay.
completed
Is it okay now?
innovation
Yeah.
from
Is it okay now?
Yes, sir, I'm there.
shared the MNC.
Yes, sir, okay.
That's great.
He
That's
will
great.
be starts joining us. The
Yes, sir, I'm
IPR.
here.
Shared his
I'm
presentation.
audible.
My place. Just because to start, I will start
He has
immediately.
started
Yes, sir.
sharing the
Our participation
Should I start?
in the next
he has
Is it okay now?
program from
Is it okay now?
Yes, sir, I'm there.
MNC.
That's great. That's great.
Starts joining us.
Yes, sir, I'm here. I'm
My
audible.
place. Just because to start, I will start
He
immediately.
has started
Yes, sir.
sharing
Our participation
in the next he has
Is it okay now?
program from
Is it okay now?
Yes, sir, I'm there.
MNC.
That's great. That's great.
Starts joining us.
Yes, sir, I'm here. I'm
My
audible.
place. Just because to start, I will start
He
immediately.
has started
Yes, sir.
sharing
Our participation
in the next he has
Is it okay now?
program from
Is it okay now?
Yes, sir, I'm there.
MNC.
That's great. That's great.
Starts joining us.
Yes, sir, I'm here. I'm
My
audible.
place. Just because to start, I will start
He
immediately.
has started
Yes, sir.
sharing
our participation
in the next he has
Is it okay now?
program from
Is it okay now?
Yes, sir, I'm there.
MNC.
That's great. That's great.
Starts joining us.
Yes, sir, I'm here. I'm
My
audible.
place. Just because to start, I will start
He
immediately.
has started
Yes, sir.
our participation
Is it okay now?
program from
Is it okay now?
Yes, sir, I'm there.
MNC.
That's great. That's great.
Starts joining us.
Yes, sir, I'm here. I'm
My
audible.
place. Just when we start, I will start immediately.
Our participants are
Is it okay now?
Yes, sir, I'm there.
That's great. That's great.
Yes, sir, I'm audible.
Thanks. We are ready when we start, I will start immediately.
Yes, sir.
our participants
Is it okay now? Is it okay now?
Yes, sir, I'm there.
That's great. That's great.
Yes, sir, I'm audible.
Thanks. We are ready when we start, I will start immediately.
Yes, sir.
our participants
Is it okay now? Is it okay now?
Yes, sir, I'm there.
That's great. That's great.
Yes, sir, I'm
Okay now? If we look at the IPR, okay now?
Yes, sir, I'm there.
I asked the audience question. Okay now? If we look at the IPR, okay now?
Yes, sir, I'm there.
Then I had decided something final. Which was the balance of my I asked the audience question. That is the very okay now. If we look at the IPR, okay now? Now
Yes, sir, I'm
I would like to have the then I had decided something final. Which was the balance of my I asked the audience question. Very fondly. That is the very okay now. If we look at the IPR, okay now? Now
Yes, sir, I'm
I would like to have the then I had decided something final. Which was the balance of my I asked the audience question. Very fondly. That is the very okay now. If we look at the IPR, okay now? Now I would like to have the then I had decided something final. Which was the balance of my I asked the audience question. Very fondly. That is the very okay now. If we look at the IPR, okay now? Now I would like to have the then I had decided something final. Which was the balance of my I asked the audience question. Very fondly. That is the very okay now. Enable them to achieve this पे टेक्नोलॉजी लैंडस्केप करता है. General practices to rather look at the chemical abstracts or journals and some of the relevant technologies and then plan the strategy. But technology landscape is a very, very important factor. There are parent databases, technology landscape, and there are strategies to develop general technology landscape. Analysis of that technology landscape pertaining to a particular technology domain enables you to look at the chemical abstracts or journals and some of the relevant technologies how the work is being carried out. But technology landscape is a very, very important factor. It also enables a scientist landscape, and there are strategies to develop general identify white spaces. Analysis of that technology landscape requirement by the industry technology domain enables you to look at the chemical abstracts or journals and some of the relevant how the work is being carried out. But technology landscape is a very, very important factor. It also enables a scientist and there are strategies to develop general because many times this analysis of that technology landscape requirement by the industry technology enables you to at the same time capture journals and some of the how the work is being carried out. But technology landscape is a very, very important factor. It also enables a scientist and there are strategies to develop general because many times this analysis of that technology landscape requirement by the industry enables you for the same time capture journals of how the work is being carried out. But technology landscape is a very containing a it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry will be only at the same time capture journals of how the work is being carried out. But technology landscape is a very containing it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a very containing it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a very containing it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a very containing it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a very it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will be only at the same time capture journals of how the work is done on that. But technology landscape is a it also enables scientists and there are strategies to develop general because many times this analysis of also higher the requirement by the industry where this will Is it okay now? Hello? I want to
No,
make
sir,
PPT.
not visible.
That's the reason I have sent it across yesterday itself. Because you have got an expertise in that.
Sir, we didn't receive your email. We have checked all the emails.
First, you have to click on
Even
onto the share screen, sir.
spam and promotions.
Is it okay
Will
now?
you please resend it, sir?
Hello?
Yeah, that would be better if you
I
resend
want
it.
to
No,
make
sir,
Email
not
it again.
visible.
Okay, I'm sending That's the reason I have sent it across. I have sent to the dean. Because you have got an expertise in
I
that.
have checked it. I didn't receive any email. Your email. We have checked all the emails.
First, you have to click on
Even
onto the share screen, sir.
spam and promotions.
Is it okay
Will
now?
you please resend it, sir?
This presentation
Yeah,
is there.
that would be better if you resend
want
it.
to
No,
make
sir,
Email
not
it again.
visible.
Okay, I'm sending That's the reason I have sent it across. I have sent to the dean. Because you have got an expertise in
I
that.
have checked it.
Spam.
I didn't receive any email. Your email. All the emails.
First, you have to click on
Even
onto the share screen, sir.
spam
Share.
and promotions. Sir, please
Is it okay
resend
now?
Will you please resend it, sir?
This presentation
Hello?
is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have
No, sir,
any
Email it
not
option
again.
of going to my rather
That's the
document
reason
file.
checking the
I have
spam
sent to the
box,
dean.
sir.
Because you have got an expertise in
I
that.
have checked it.
Spam.
I didn't receive any email. Your email.
Uh,
First, you have to click on
Even
onto the share screen, sir.
spam and promotions. Sir, please
is it okay
resend
now?
Will you please resend it, sir?
This presentation
Hello?
is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file.
Checking the
I have
spam
sent to the
box,
dean.
sir.
Because you have got an expertise in
I
that.
have checked it.
Spam.
I didn't
Click on present now, and then you are
I'll
entitled.
just
First, you
just
have
hold
to
on.
click on
I
onto the
will try
share
to do
screen,
that.
sir.
spam and promotions. Sir, please
Is it okay
resend
now?
Will you please resend it, sir?
This presentation
Hello?
is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file.
Checking the
I have
spam
sent to the
box,
dean.
sir.
Because you have got an expertise in that. I'm not able to do
Spam.
that.
I didn't
Click
no
on
problem,
present
sir.
now,
Please
and then
resend
you are
it.
I'll
entitled.
just
First, you
just
have
hold
to
on.
click on
I
onto
will
the
try
share
to do
screen,
that.
sir.
I'm sending it. Is it okay now? Which email ID I have to send it? This presentation is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file.
Checking the
I have sent to
spam
the
box,
dean.
sir.
I'm sending it to because you have got an expertise in that. I'm not able to do
Spam.
that.
I didn't no
Click on
problem,
present
sir.
now,
Please
and then
resend it.
you are
I'll
entitled.
just
First, you
just
have
hold
to
on.
click on
I
onto
will
the
try
share
to do
screen,
that.
sir.
I'm sending it. Is it okay now? Which email ID I have to send it? This presentation is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file.
Checking the
I have sent to
spam
the
box,
dean.
sir.
I'm sending it to because you have got an expertise in that. I'm not able to do
Spam.
that.
I didn't no
Click on
problem,
present
sir.
now,
Please
and then
resend it.
you are
I'll
entitled.
just
First, you
just
have
hold
to
on.
click on
I
onto
will
the
try
share
to do
screen,
that.
sir.
I've sent it. Is it okay now? Which email ID I have to send it? I've sent it. Is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file. I sent to the dean. I'm sending it to because you have got an expertise in that. I'm not able to do that. Else I would have
Click on present now,
arranged
and
before.
then you are
I'll
entitled.
just
First, you
just
have
hold
to
on.
click on
I
onto the
will try
share
to do
screen,
that.
sir.
I've sent it. Is it okay now? Which email ID I have to send it? I've sent it. Is
Yeah,
there.
that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file. I sent to the dean. I'm sending it to because you have got an expertise in that. I'm not able to do that. Else I would have
Click on present now,
arranged
and
before.
then you are
I'll
entitled.
just
First,
is
you
it
have
okay
to
now?
click on
I
onto
will
the
try
share
to do
screen,
that.
sir.
I've sent it. Is it okay now? Which email ID I have to send it? I've sent it.
Yeah, that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file. I sent to the dean. I'm sending it to because you have got an expertise in that. I'm not able to do that. Else I would have
Click on present now,
arranged
and
before.
then you are
I'll
entitled.
just
First,
is
you
it
have
okay
to
now?
click on
I
onto
will
the
try
share
to do
screen,
that.
sir.
I've sent it. Is it okay now? Which email ID I have to send it? I've sent it.
Yeah, that would be better if you
I
resend
don't
it.
have any
Email it
option
again.
of going to my rather document file. I sent to the dean. I'm sending it to because you have got an can be granted to an innovator for 20 years as a proprietary right. But for that, what innovator has to do? Innovator has to disclose his or her invention to the public at large. By disclosing itself, they get a right. If they don't get it otherwise. And what is something which is granted? It's not something I say that I've done this for 20 years as a proprietary right. Be done, for that, what innovator has to do? Patentable. Innovator has to disclose the next slide, her invention to the public at large. By disclosing itself, they get a right. This is a result of human intellect. If they don't get it otherwise, human creation. And what is something which is granted? It's not something I say that I've done this requirement. 20 years as a proprietary right. Be done, for that, what innovator has to do? Patentable. Innovator has to disclose the next slide, her invention to the public at large. I'm talking about the patents only. By disclosing itself, they get a right. This is a result of human intellect. If they don't get it otherwise, copyright is what is something which is there we are something I say that I've done this requirement. 20 years as a proprietary right. For that, what innovator has to do? Patentable. If you look at it, there are really requirements. One is industrial application. To the public at large. Whatever innovation disclosing itself, this is a result of human intellect. If they don't get it otherwise, copyright is that is something which is there we are something I say that I've done this requirement. So the requirement is no must be done. For that, we should have not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Whatever disclosing itself, this is a result of human intellect. If they don't get it otherwise, copyright is that is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should have not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Whatever disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, copyright is something which is there we are something I say that I've done this requirement. Even though the requirement is no must be done. For that, we should not innovator. If you look at it, there are really requirements. One is industrial application. To the public at large. Disclosing itself, that is a result of human intellect. If they don't get it otherwise, City, a word you might have seen many patent WO. Am I right? Anybody? City, many patents starting with WO and the number. You might have seen many patent WO. Am I right? PCT patent application. Anybody? They said within 12 months, many patents starting with WO and the number. You might have seen many patent WO. Am I right? PCT patent application. Where anybody? They said within 12 months, many patents starting with WO and the number. Am I right? Then PCT patent application. Where anybody? They said within 12 months, many patents starting with WO and the number. Am I right? Then PCT where anybody? They said within 12 months, many patents starting with WO and the number. Then PCT where anybody? They said examiner in your PCT application has been examined. Examiner in that category, your application has been examined. And application has been idea. Application has been idea. Application has been idea. Application has been application has application has to the buyer that let him or her do anything whatever they want to do with your patent, and you get the value of your patent. And patent value evaluation, that is net physical value, net financial value, and that is arrived at using so many factors. There's so many arithmetic calculations used to arrive at the patent value. That all depends on how much value addition is going to do, for how much period it has active protected, because it is 20 years from the date of publication, from the date of priority, from the date of filing. When it gets granted, from grant onwards, how much time is left. In how many other countries, whether there is a scope to file in other countries or not. If you have filed a PCT application, yes, 30 months window is there. If you have not filed anywhere else, only 12 months window is there. Whether that window has lapsed or there is a provision still. All those factors are taken into consideration while deciding at the valuation of the patent. And if at all you have got a PCT application and you want to give rights to a specific person only for one jurisdiction and find out other buyers from other countries, that all depends upon, all the rights are with the patent owner. May I go to the next slide, please? As I've already told you, who may obtain the patents? Patent can be obtained by any innovator on design or technology. Next slide, please. This I've already explained to you. Utility patent 20 years, design patent, now it is 15 years, earlier it was 14 years, 10 plus 5. Next slide, please. Primary requirement, I've already told you. I have told you the patent can be obtained by only disclosing one's invention to the public in the form of a patent document. Next slide, please. Now I come to the Indian patent law. Indian patent law, it has been enacted taking into consideration TRIPS agreement. What are the guidelines TRIPS agreement provide? As you know, in pharma patents in particular, earlier in India, only process patents were allowed. There was Section 5. Section 5 did not allow product patents to be granted in India. However, TRIPS agreement Article 27 says that invention of any member state has to be respected and honored by all other member states. And in 1984, there was a Doha meeting of the WTO member states where it was decided that within 15 years, all the member states have to enact legislation complying with TRIPS agreement. So effective 2005, India has to enact in line with TRIPS agreement. So therefore, Section 5 was removed. Now both product patents are also rather allowable in India. And in drug patent, what happened is, as you know, are there some chemists or pharmacists in the audience? Hello? Anyway, let me tell you, in the pharmaceutical products, the product patents are for a molecule, chemical molecule. A chemical molecule has different salts and different isomeric forms also, and different polymorphic forms also. And there has been a practice by many pharma companies to have different patent for different salts and polymorphic form of the patent. Therefore, the basic molecule is one, whose patent is for 20 years. After every 2-3 years, they keep on adding patents. Therefore, they keep the patent active for 40 years, 50 years likewise, not enabling their competitor to come out with a generic form of that product. Therefore, making the drug inaccessible to public at large, because patented products are very expensive. So India, for that matter, has enacted legislation wherein it says it has created a Form 3D, which is really something for which a lot of discussion was held in US Assembly also, in European assemblies also. 3D section says patent of any form of an existing molecule product is not allowable in any new form, in the form of acids, polymorphic form, esters, likewise, unless and until there is a proven efficacy, enhanced efficacy for that. For proving enhanced efficacy, one has to undertake clinical trials, which is a very expensive matter. Therefore, many multinational companies, Novartis, there was a case which went up to Supreme Court. Similarly, case of Merck went up to Supreme Court against Denmark, wherein patents of the salt form was not granted at all. And they felt really bad, and the matter was discussed at length at the government levels also, and likewise. And furthermore, TRIPS agreement also says, many times what happens, somebody finds a patent primarily as a bottleneck for their competitors, that their competitors do not excel in that technology domain, though they don't want to use the technology. Therefore, patent law as such says, from the date of grant, within 3 years, patent has to be used. There is a provision by the Indian patent law that for every granted patent, every company, they have to submit Form 27 on yearly basis to the patent office, wherein they have to state in detail the product made based on this technology in their company and earnings out of that in rupees, in value. If it is not done, it is a non-compliance of the law, and competitor parties can certainly oppose and ask for the compulsory licensing of the patent to them or revocation of the patent. These are the primary requirements one has to comply with. Another provision in Indian patent law is a compulsory licensing. Likewise, I told you, if at all some patent which has been granted is not being used by the patent holder, then competitor can put up an application that is under section 85 of the patent law. That's under section 85 of the patent law, wherein they can ask for the compulsory licensing for that patent. There are two ways. Either the patent holder can give the voluntary license based on the mutual agreement. This is how they will be giving the royalty or one-time cost. Likewise, if at all patent holder disagrees to give the voluntary license, then they can put up an application to the patent office asking for a compulsory license under section 85. Secondly, Indian government has got a right. Whatever they think is in the national interest, there is an emergency, and some of the patents are bottleneck, and there is a prime need for this patent to be used and made accessible to the public at large. Then under section 92, Indian government can have that patent readily available to the needy users for compulsory licensing under section 92, for which they do not have to fight with the patent holder. Government has already taken care of that. They just have to approach the Indian Patent Office asking for the compulsory license. Another very important factors in the Indian Patent Office is an opposition. Many times, innovator is a smart, or innovator's patent agent or attorney is smart. They somehow get a patent on their invention. Their competitor or some party, they choose this patent which has been granted is not patentable invention for some reason. One of the prime basis for challenging such patent is a prior art. They find out some prior art. Prior art means patents are publication predated to the date of filing of that patent application. Before the filing date, based on which they can challenge novelty and inventive. If you remember at the beginning, I said obviousness. A person skilled in the art, even though novel, though inventive as claimed by innovator, but person skilled in the art can say, no, it is something which can be done. Therefore, it should not be, it's obvious to person skilled in the art. Based on this aspect, this is one of the primary reason, obviousness, based on which patents are challenged and get revoked, or patent holder scaring revoke, they enter into an out of the court settlement with the opponent, telling you take out your opposition back and I'll give you voluntary license for that. So that patent is also not revoked, patent remains alive, and the opponent also get benefit of using that patent technology. based on mutual agreement, whether some royalty or not. And there are two ways. That one is pre-grant opposition, second is post-grant opposition. Pre-grant opposition is something while the patent application is under prosecution. In general, in India, once you put an application, as per the practice, within 18 months, the patent gets published. Though there's a provision under law by submitting a Form 9 along with the government fees, wherein one can get a patent published within 1 month. It comes in public domain. Competitors, they create landscape, this and that. When they find this patent is something which I should challenge, it will be a bottleneck to my industry, my operation, they can put a pre-grant opposition by submitting Form 7A, challenging, giving reasoning why this patent should not be granted, and they ask the controller, please take cognizance of whatever observation I'm making in my pre-grant opposition document while examining, and give me a opportunity for hearing before you grant, so that I can present my case of opposition in person along with the applicant, and they argue and decision is taken accordingly. And another provision is post-grant opposition. Post-grant opposition, there are two provisions. One is if within 12 months from the date of grant, it is at a controller level. Within 12 months from the date of grant, it can be put to the controller for review of his decision and ask for the hearing and put up their case in the form of document opposing the patent, giving reasoning for the opposition, why it should have not been granted, why it should be rather rejected, and asking for the hearing. If the time has passed over 12 months, then controller does not have any right to that. It has to be put to IPAB. There is a board, Intellectual Property Appellate Board, which comprises a judicial expert, where Mr. Singh is appointed by the Government of India to IPAB, and a team of experts. They review it, the document and the reasoning for the opposition by the opponent, and they are called for the hearing like in the court of law, because IPAB has got a judicial powers. It is in the form of a court itself to look at whether patent granted should stand granted or should be removed. Our matter is argued and accordingly decision is taken. Next slide, please. Next slide, please. These are the different how. Next slide, please. I have already explained all this thing to you. If there is any question somebody has on these slides, you're free to ask me. Next slide, please. So this is what I have explained to you all in totality, the prosecution. When you say this patent grant in India, once a patent is granted, it can be opposed also, and it has to comply with by submitting Form 27 periodically, else it can be done. And TRIPS agreement set Article 31 says, even though Article 27 says that each member state of WTO must respect the IP of fellow member states. However, it also states under Article 31, there was a Paris Convention, Paris meeting, and Doha meeting. In both the places, it was decided that many times, particularly drug patents, they rather make the drugs which are based on patents inaccessible to the public at large. So this creates a national emergency. For that reason, they have said that there is a provision for compulsory licensing. For this reason, they says the respective WTO member states can enact legislation wherein compulsory licensing provision can be provided, and it is up to the respective member state to decide the state of emergency. For example, if you look at it, about 3 years ago in India, there is a case study between Bayer and Cipla. Bayer had a product which was being sold at very high price. I think it was 7,000 rupees per month value. 30,000, sorry. And Cipla said they will, Netco said they will provide it at the rate of 770 rupees per month dosage. Then Cipla was already making that drug, and the case was going on between Cipla and Bayer in the court. Bayer had put up an application to the patent office for compulsory licensing, telling there are three factors which were assigned. First was, how much is the requirement for this drug in India? X amount. How much drug was being provided by Bayer to the Indian market? It was 30% of that X amount which was required. That was the one reason assigned. Second reason, the price. 30,000 vis-a-vis 7,700 per month. Then the buyer said they will provide a provision. If at all somebody buys for 1 month, they will give 2 months free. That also became expensive. And there were a lot of arguments. Government of Indian Patent Office had given a compulsory licensing to Natco. Then the buyer said, since Cipla is already making, why there is a need for compulsory licensing to Natco? Then the court says, you have not allowed Cipla to make. You have already filed an infringement case against Cipla. So let us not mix up with this. Then 5% royalty was decided by the Indian Patent Office to Bayer by Natco making that product. Had Bayer been intelligent, they would have considered voluntary licensing at much higher price, much higher royalty. And later the matter was escalated to IPAB, which increased to 6% royalty, and then to Supreme Court. Supreme Court increased 7% royalty. I'm giving you a live example of compulsory licensing as per the Indian Patent Law. Next slide, please. These are the different amendments of the Indian Patent Law it has gone through. I need not elaborate on that. Section 3, as I told you, Section 3D explained. Section 3 states what are the reasons which bar the grant of patent in India. 3D I explained to you that pertains to pharma sector. Then there's the 3K which pertains to the software section, which it says per se. Software patent can be granted per se. Per se means use in the industry. And the different section. I did not elaborate on that. Next slide, please. These are the different sections which rather tell in detail what is patentable, what is not patentable in India. Next slide, please. As I have already explained, person skilled in the art. Who is the person skilled in the art? It's a very Section 3 is something which says non-patentable inventions in India. I have explained to you about the pharma sector. Next, please. Next slide, please. I have already explained to you salts. Then in agriculture, a method of agriculture, horticulture is something which is not patentable in India. Another factor in pharma sector is method of treatment. How a treatment can be induced to a patient. That claims on that aspect are also not patentable in India. Next slide, please. A mere scheme or rule of method of performing mental act or method of playing game. These are also something which are not patentable in India. A presentation of information, a topography of integrated circuits, all this relates to the software sections. Next slide, please. Microorganisms. Excluding microorganisms per se from patent protection would be violative of TRIPS agreement. TRIPS agreement also says that in agriculture, microorganisms per se should not be patentable. That comes under Section 3J. Next slide, please. energy-related inventions not patentable under Section 4. No patent shall be granted in respect of an invention related to atomic energy, falling within the subsection for Section 3, because these are of the national interest. Anything which is of national interest cannot be made public. Then energy-related invention are patentable under Section 4. No patent shall be granted in respect of an invention relating to atomic energy falling within subsection 4 as explained to you. Anything which is of national interest cannot be put in public domain. Next slide, please. Section 3, I have already explained to you in detail. Is there any question on that? Please feel free to contact me. Please feel free to talk. Any question? 3D is something which is in real discussion among most of the pharma multinationals in all over the world. Any question on that? I'll explain in detail about what is 3D.
No, sir, no questions.
Okay, next slide, please. New chemical entity and NME. What is new chemical entity? Any new molecule which can graduate into a drug molecule by going through all regulatory requirements. Whereas in US is a major world drug market, biggest market, next comes Japan. India is at very low level. So new chemical entity, then new mechanical entity, these are new inventions, and test of patentability must be new, not obvious, have utility, industrial application. These are the requirements for getting a patent on new product in the form of new chemical entity for drug or pigment or any chemical sector, and NME for a other sector. Next slide, please. As I told you, if a new chemical is there, esters of a new chemical, isomeric forms of a new chemical, salts of a new chemical, of a new molecule, they are also new chemical entities. Though they are patentable in US and Europe, but in India under Section 3D, they are not patentable. Whereas in other countries, they are patentable. Next slide, please. And they are patentable only if at all they are supported by a clinical trial data in support of enhanced efficacy. As I told you, going beyond the test of patentability, they say not patentable. Derivatives of known substances cannot be patented unless they can be shown to differ in their terms of efficacy, which I told you about. Next slide, please. The same thing which I explained to you. Next slide, please. And also, I would like to emphasize the fact, if there is a drug molecule for which there is a patent and drug is there in the market, in the public domain, that drug is being used for a specific indication, for a specific disease. However, a new application of the existing drug is found that it can treat other ailment also. For this, in India, there is no provision for patent because they say this product is already known. And that characteristic which is new, which has been found, was inherently present in that molecule. It was inherently present. Therefore, there is not creation of that characteristic by a human intellect, though human intellect has found it out. So in India, that is not rather patentable. Next slide, please. So as I told you, there are so many examples, so many Nobel Prizes which have been granted on different inventions for which patents were granted, and they were told worth billions of dollars. Some other day, I will give you the data of patent monetization. And let me tell you, India also has a lot of intellect, but for some reason, that remains curved and latent. I think many people might have heard of CBS catalyst. There is a CBS catalyst which is used for stereospecific oxidation of an hydroxy group. Sorry, reduction of an carbonyl atom to an hydroxy. Stereospecific reduction. And you know CBS stands for what? Corey, Bakshi, and Shadrell. Corey is a Nobel laureate from US. B is a Bakshi, Raman Bakshi, who is an Indian, and fortunately he was my classmate right from my school days to university. And Shadrell is a Japanese scientist. Indians have capability of creating inventions which can be rather considered Nobel Prize also. Somehow, for some reason, things are obvious that they're not being pursued properly. Next slide, please. This is an innovation. I have highlighted some of the innovation from the academic institutions, because wherein you can find out how academic institutions have been getting a lot of benefits, advantages by creating inventions and monetizing on those inventions, forming a strong base, both encouragement, individual encouragement, financial benefits also. Look at this. This entry to the market of the first product in the new class is followed by a number of other products offering alternative therapeutic and side effects profiles. The resulting market include, these are the inventions, some of the examples I'm citing, where these innovators have got patents on a new thing. When I say, you might ask me, what is enhanced therapeutic efficacy? I will cite an example. Supposing a molecule has certain side effects, and you make a different form of this molecule in the form of a salt, ester, or physical crystalline form, which is called polymorphic form, wherein for some kinetics, the side effect gets reduced. This reduction of side effects is a theoretical efficacy. Similarly, if some drug is being given in supposing 10 milligram dosage form, you rather find out some specific salt or specific isomeric form or specific polymorphic form, which has, due to dissolution and therapeutics, or I would say its bioavailability increase, movement in the body, carrying in the body to the site, bioavailability increases, and dosage forms can be reduced from 10 milligrams to 7 milligrams or 6 milligrams. That is a therapeutic efficacy. These are the factors which should be supported by clinical trials. For the same molecule of different form, one can get a patent on this thing also. Clear? Next slide, please. These are the biosciences innovations, different innovations. Have you cited some examples, some different technology domains under which a lot of research is being carried out, and lot many patents are being obtained on this. That's the reason I've told you, for any technology domain, any technology leader or professor, they must have a technology landscape of that technology domain, analyze, identify the white spaces, and get in touch with specific industries to get a joint, rather sponsorship or financial help, develop some products which are usable and can be licensed out. Next slide, please. I told you new uses of medicines is something for which one cannot get a patent. It's the new uses of medicine are often discovered as a result of extensive medical experience, often many years after introduction. For example, tissue plasminogen activator now used in stroke forms. Some incremental innovations have been demonstrated to save overall healthcare costs as well. For example, a study of the National Institute for Neurological Diseases and Stroke found that patients treated with TPA had shorter hospital stays than other patients and were more often discharged to home rather than to institutional care. Although hospital costs for treating patients increased by 1,700 per patient, rehabilitation and nursing home costs are reduced by 6,200, and that's this sort of innovations for a new products or new discovery are patentable, because in a tangible manner there is a benefit of this invention in that technology domain. Next slide, please. Incremental innovation is vital for drug discovery, and many Indian companies and institutions, including government like CSR, etc. Therefore, the patent law needs to make the journey to world class by modifying class 3D. Now they say 3D is something. They say sometime an incremental increase. Incremental increase in an existing product. There should be certain amendment in section 3D. It should not be that strong, straightway refusing it. But there is a provision with some examples in Indian industrial sector also, which dissuades many innovators. Though they see they can get a patent by some incremental improvement, innovation, but they're being denied their rights under section 3D. Next slide, please. Efficacy, I have explained to you one case of efficacy 3D. Chennai High Court neglects one case of Cipla and Novartis, which went out to Supreme Court, wherein this Novartis had given a data in respect of bioavailability for a salt form of a molecule. This original molecule was not patented in India. They had put an application for the salt form of that patent in India. And Cipla had challenged that patent under section 3D. This patent was rejected by the Indian Patent Office under section 3, telling this is a salt form of a known product. Therefore, it's not patentable. And the matter was taken to the Supreme Court based on the data provided by the Novartis that there is a proof and data for increased in bioavailability of this salt form of drug molecule. But Supreme Court did not agree with that. He said bioavailability increase has to be supported by a efficacy which is in the form of, is there any result in decreasing in dosage quantity? No. If at all you provide a data in respect of increased in efficacy supported by reduction in dosage quantity, then we can agree. Only merely saying bioavailability increase is not an efficacy. This is a live example, and Novartis was very disturbed with this decision. Next slide, please. I'm citing this with an example. Drug X and X1 have the same efficacy. X1 2 times shelf life compared to X. X1 more useful for patients. Shelf life related to stability. Efficacy relates to effect on patient. You say there's live example because X is a drug molecule who has got a shelf life, because its shelf life is only 1 year, let us say. After 1 year, it degrades and therefore cannot be used. However, he makes a X1 form of that molecule in the form of a new acid or new salt or new ester. And it says shelf life of this new form of this drug has 2 times more stability, shelf life. Compared to 1 year of usability, it has a 2 years of usability. But court says this does not have any impact on the patient in respect of its use. It is only storage. Therefore, this cannot be taken as a tangible form of enhanced efficacy. Next slide, please. There is an example which I just said. Nucleoside is a painkiller. It is a causing damages to the liver. Side effects: nucleoside without hepatotoxicity deficiency has advantage over nucleoside with the hepatotoxicity. Improved version is a new form of known substance. No significant improvement in the efficacy as compared to the known form of nucleoside. Does it satisfy 3D? Is a question mark. One has to argue, and it has to be supported by the clinical trial data, not otherwise. Next slide, please. Thermal stability, 3D. There is a clopidogrel bacillate, which is a drug which is used for reducing cholesterol. Must term efficacy be construed as therapeutic efficacy only as was interpreted by Madras High Court? If yes, would amendment be effective to section 3D to replace efficacy with the term therapeutic efficacy to impart clarity? As I told you, 3D is something which is very stringently followed in India. As I rather cited that there must be certain pondering over this matter and certain explanation in defining this 3D. For example, clopidogrel bacillate salt has got increased thermal stability compared to the clopidogrel based molecule. Patent has been granted. In this case, how? We don't know. There must have been a lot of arguments. Whereas in nucleoside, it was denied, whereas in this case, it is granted. But it can be challenged in the court of law also. Next slide, please. Because 3D is being pursued and practiced in a very dubious manner. Gilvic, imatinib, bacillate salt, efficacy not supported by clinical data. As I told you that Novartis case, you know, a while ago I just explained Novartis case against Cipla. It went to Supreme Court. That was pertaining to this drug molecule, wherein Supreme Court rejected the patent application. Did not. There in the thermal stability, they are granting it, whereas in this bioavailability data, they are rejecting it. Next slide, please. Merck sitagliptin 3D case. This has also been a very, very important case between Merck and Glenmark. Sitagliptin original molecule has been patented in India, and they had put a patent for phosphate salt of this drug molecule also in India. Glenmark had been making a dosage form in the form of a phosphate salt. The case was put against Glenmark in Supreme Court by Merck. It went on for years together. Later on, though the phosphate patent was not granted, based on that, Glenmark has been making that we are making a product which is not granted in India. Therefore, we are free to use it. However, phosphate salt is also of a clopidogrel for sitagliptin basic molecule. They say since we are using sitagliptin molecule for which we have got a protection, therefore you are infringing. Supreme Court agreed on this aspect, saying yes, Glenmark cannot use this, they are infringing it, not because they are using phosphate salt, because they are using sitagliptin basic molecule also in making phosphate. Therefore, this though patent was rejected, and it was ruled that Glenmark is infringing, and how they reach out of court settlement, that is not in public domain. But Supreme Court had asked Glenmark to stop making this drug molecule. Next slide, please. Now, as I told you, one of the prime reason of challenging a patent is an obviousness. In US, it is under Section 103, and 90% of the patent in US are challenged in the court of law under Section 103, wherein it is defined a person skilled in the art would have done it as such from his common logical manner. It is obvious to a person skilled in the art. It does not need or involve any human intellect to do something which is not obvious, for which one had to carry out a lot of experimentation and thinking and put one's intellect. But now for that, it is very important to understand what is the level of person of ordinary skill in the art. These are the factors: education level of the inventor, type of problem encountered in the art, prior art solutions to those problems, rapidly with which inventions are made, sophistication of the technology, education level of active workers in the field. These are things, and the word patent comes from the Latin word literal patenti, meaning an open letter, because you put your patent document in the form of a letter against for which you get a proprietary rights. These are the different levels. A court can take a call to identify a person of ordinary skill in the art of the specific technology domain. Next slide, please. As I have already explained to you with the examples of turmeric and the grass, can a natural product be patented? Answer is no, which I have already discussed in detail. Next slide, please. These are some important case study which I have identified in respect of patentability. A naturally occurring DNA segment is a product of a nature and not a patent eligible merely because it has been isolated. However, DNA is a patent eligible because it is not naturally occurring. cDNA. We say it is a very, very important case in USA between AMP and Mirrored about DNA molecule. DNA as such, which is occurring in nature, and human intellect is involved only in isolating it. Therefore, if at all there is some special technique used in isolating, one can certainly get on a process of isolating DNA, but not DNA as a molecule. However, if at all an engineering has been done on a DNA to create a cDNA, then it becomes eligible for the patent. Next slide, please. Similarly, natural occurring DNA segment not patentable eligible, which I have explained to you. Next slide, please. Same case is continuing, is a very, very strong case in the US, which has been discussed all over the world about patentability of a of this DNA biochemical factors. Next slide, please. Is the next slide? Same thing is there. It explained it rather there's no need to going in micro level. This is a very obvious thing. Please carry on. Natural product and modified natural product. This is another thing which is a very important factor. Amazonic acid, which is present in Amazonic cherry tree and is known to be effective in breast cancer treatment, but need to consume equivalent to 30 pounds of leaves for several weeks. There is a acid which is available, which is found in a natural source, and that natural source Amazonic tree and cherry tree. This has been found to be responsible for curing breast cancer. Panazonic acid is a product which is isolated. I sure, if at all I put a claim in my patent that I have isolated Amazonic acid in a pure form, whereas in the leaves, as I told you, one has to take 30 pounds of leaves. Instead, I isolate this acid in pure form and only acid is given. I put a claim 1 on purified benzoic acid, and I put claim 2 purified 5-methyl benzoic acid. Can anybody tell me if I can get a claim granted as claim 1 as granted purified Amazonic acid? Please share your viewpoint. Can anybody get a claim on purified Amazonic acid which is obtained from the natural source, though it is purified? Anyone? Please. Though purified, but the product is same, which has been isolated
Sir,
from the
process
natural source.
patent?
Pardon me?
Process patent can
You can get a process patent if process has got certain inventive features, because getting a natural product from natural source, that is oxidation, is a standard process. If you have used some special technique in isolating it, then you can get a process patent. Merely isolating is no. And you
Sir.
cannot get a, say, yes please.
So Amazonic acid also should not be patented because it's just a purified form.
No, it is not, because purified is a product which is already there in the nature. You have isolated it and you have
Yes,
purified it. Purification is the standard process of purifying it. But it's a product as such is not patentable. However, you modify this acid which you have isolated from the nature to 5-methyl Amazonic acid is a different product. You have got a product from the natural source, you have chemically changed into its 5-methyl, and you find that this is something which can also be used as a drug molecule in a better way. There's a human intellect. By creating this 5-methyl derivative of this Amazonic acid, you can certainly get patent on too. Now, method of treating colon cancer comprising administering. In US, you do get a method of treatment patent, because earlier you were eating only 30 pounds of leaves, by which one was getting cured. In this case, you are isolating a pure form of acid, and you are coming out with a method of treatment using this purified acid, which was not there earlier. On that, you can get a claim, but not in India, because in India, under respective section 3, you cannot get a patent on method of treatment. Next slide, please. Here, I have whatever explained to you. Not satisfied because no structural difference between acid in the claim and acid on leaves. Though claim 1 is not eligible. Claim 2 eligible, as I explained to you, because human intellect has been used in modifying to 5-methyl. Yes, claim 3 eligible in US method of treatment. Is that clear?
Yes, sir.
Next slide, please. Same thing which I've explained to you in detail. Next slide, please. Next slide, please. Claim 3 eligible. Now, this is all which I've explained to you, patent eligibility in respect of novelty and inventions. As you might recall my earlier talk on obviousness, there has been a landmark US Supreme Court case, that is KSR Telefax. These are the two companies, KSR Telefax. Earlier, what was being perceived by the examiners of the patent office was to take an individual patent reference or individual prior art reference, not only patent, even publications, as relevant to their claims, not combining all together into one and then ascertaining by combining all the prior art references. And then obviousness was ascertained whether it is obvious or not. In KSR Telefax Supreme Court case, which pertained to a mechanical machine claims, wherein one prior art has some factors, another prior art has got some other factor, third prior art has the other factor, not related to same product, different product, but conceptually same, functionally similarity. Then Supreme Court says, obviousness can be rather ascertained by combining so many factors from different prior arts, may not to the same subject matter, even on different subject matter, but functionality should be the similar. Combining all that in a logical manner to arrive at its obvious or not. Can you imagine? In that case, district court had said it is patentable, patent is legible. Federal Circuit Court has said patent is cannot be revoked. It's the Supreme Court which eventually decided patent is not legible. It was a landmark Supreme Court judgment, KSR Telefax, wherein this breadth of obviousness has increased considerably to arrive at obviousness. You know, what are the authorities in India? Controller General of India, Design and Remarks under Department of Industrial Development, Ministry of Industry. That's the authority in India. Next slide, please. Now, what is the process of getting a patent in India? There are different ways. There is a definite process. You know, when somebody gets an idea, does some initial work, finds out, yes, this is something which is patentable. But one has to do a lot of work which is in his mind, but has not carried out, has not generated data. Says it will take a while. But law says first to file, not first to invent. Maybe during this time, somebody else may file. So there is a provision of filing a provisional application. You put your idea, some experimental data, and also what you want to do it more. But you have not done it, but you want to do more. You want to have so many things in the scale, in the scope of this patent, your invention. Put up an application, not writing claims. Because, please note it, maybe a 100-page patent document, but proprietary rights are only one sentence or one paragraph claim. It is the whatever has been claimed, whatever claims have been granted, is the scope of your proprietary right, which is quoted by the document of other 99 pages. That is to be quoted in the specifications. So there's a provision, you file a provisional application without claims, defining about your invention and also writing the scope of the invention for which you have to carry out work which has to take this thing. Then as per the law, this is never published. Your provisional patent application is never published. It remains on the record and you can take a priority on that. If anybody files after that date, you can file it out. You are the first to have a priority on this invention. Therefore, you have got a right over anybody else. And then within 12 months, you have to file complete specification. Within 12 months, mind you. Even though the patent term in India will be from the date of provisional filing, whereas in US, it is 1 year addition you get. The patent term 20 years from the date of complete specification filing. It's not so anywhere else in the world, only in US. And unity of invention is a very important factor. Supposing in one invention, you say, oh, this invention is about this also, this also, this also. There are so many factors. There are two types of claims in a patent. Independent claims and dependent claims. Independent claims are the main basic invention. Dependent claims are the limitations of the independent claim. You can have one invention in one patent application. You cannot put, even if you have got more than one independent claim, you can put it. But those independent claims should be pertaining to one invention only. If there should not be other aspects of invention in that invention, it's called unity of invention. Only one invention is allowable in one patent application, not more than one. If there are two, then they are rejected, telling no, file another patent for that. It is called unity of invention. Next slide, please. There is a very, very important case study of a drug molecule. Obviousness. I told you obviousness. I have written some articles also on this particular case study. This is an aripiprazole is a Ostuka molecule. As you know, I have given a structure of this molecule here. Here you see a left-hand side dihydrocarbostyrene moiety, and right-hand side there is a piperazine and phenyl ring moiety, which is attached through a ring, that is butoxy linker. Next slide, please. You know, in this case in particular, earlier slide you come to that. Earlier slide, please. Aripiprazole slide. Yeah. In this case, you know, on the right hand side, you will see a chloro group at position 3. There was a prior art already in the public domain, wherein there was a molecule wherein the linker was 3 and there was no chloro molecule, rest other molecule was known. Other molecule was known. Or molecule with chloro at position 2 and 3 on the right hand side was not there. That was the only thing. Don't you think it should be obvious? Because this is a modification of an existing molecule. You know, there were opposition to this patent by the biggest multinational companies like Ostuka, this Israeli companies, from India, Sun Pharma also, Teva also, that this patent should be revoked. Matter went out to Supreme Court. Why? Because the innovator could provide a data telling when I do not have this chloro. Earlier there are molecules wherein I had put one substitution here and it was C3 earlier, C4 linker. Then the activity decreases. There showed it dissuades a person skilled in the art not to go further by having a C4 linkage and put any chloro derivatives. Instead of that, because of my intellect, I carried out research. I carried out researches and found it out that by putting chloro at position 2 and 3 and C4 linkage, I could get a molecule which could graduate to a drug by the drug authorities. Therefore, there is inherent non-obviousness, not obviousness. It's a beautiful case study. You got it? Such things also happen. I've written a big article on this case study. Next slide, please. Now, this traditional patent system, it explains. It's a local patent application allowed within 12 months by multiple foreign application claiming priority under Paris Convention, multiple formally requirements, searches, publications, multiple examination, prosecution of application, translation and national fee required at 12 months. This is a traditional patent system. As I told you, within 12 months, you have to file it. If you're filing in a jurisdiction where English is not their official language, you have to get the translation to be done. And within 12 months, it has to be filed. 12 months I have said. And if at all, within 12 months, you have to file in all other countries wherever you file. Otherwise, you lose a opportunity. Next slide, please. Then I have already explained to you, PCT came into limelight, that you rather file a PCT application by which a PCT you have to file in one language only, and it gives you a wider window of 30 months for filing in any other place, and same legal effect as a national application in each state. And you can file in all other member states anywhere in the world within 30 months time. In India, there is a 31-month time. Next slide, please. Why use PCT? I have already explained to you. If there's any question, you are welcome to ask me. That ease of filing, gain additional time to make final filing decisions, to get information licenses, capital partners, prevent the right to continue prosecution in any PCT member country, get global publicity for your invention via PCT application, delay costs in the sense, if you think your invention is something that you want to file in other countries, you have to do within 12 months time, and it's a very expensive. It is a very expensive matter. Whereas PCT provides you 30 months time with delays time. That you got any question?
Sir, what is the full form of PCT, sir? PCT.
Patent
Full form.
Cooperation Treaty is a patent cooperation treaty between the WTO member states.
Okay, okay, sir.
Okay.
Okay, sir. Okay, sir.
So this is what it says. Next slide, please. If there is any question, you are welcome to ask me any time in between. Next slide, please. Next slide, please. Is there next slide? Or it's over? As I told you, these are the different ways by which you can get a intellectual property right on any product in the form of trademark, copyright, trade secret, design, or patent. So with this, in India, as I told you, I would like to explain to you the prosecution process in India also. Once you file a patent, complete specification, not provisional. Once you file a complete specification, as a matter of fact, it takes 18 months for your document to get published. However, there is a provision by submitting Form 9, by which within 1 month it can be published. Once it is submitted, then it is examined. In India, earlier there was a delay that there was a, I think behind 2 to 3 or 4 years, but now it is picking up. Within 1 year or 2 years, they get an examination report, wherein examiner put forward his or her viewpoint, denying the claims and raising objections and finding prior art that is already known, and whatever you have claimed is obvious in respect of the prior art which the examiner cites. Then within 6 months from the date of examination report, please note the timeline, 6 months, you have to put the response to the office section. This examination report is called as an office section. You have to give a response to the controller countering his or her his findings, objections, and justifying, saying this is not related to your invention at all because of these reasons. If controller is satisfied with your statements, counter statements, then it can be granted. Else, there may be another rejection or hearing. They call you for hearing, one-to-one hearing, discussing with you in person, and these days is a video conferencing. And during hearing, if controller gets satisfied, then they tell you to submit in writing details of their discussion, justifying your claims. If satisfied, then patent gets granted. This is the process in India. And as I told that during prosecution, there is a possibility that your competitors who see this as a threat to their business, they put a pre-grant opposition. And if a pre-grant opposition will be rather sent across to the innovator, they have to respond countering that whatever is stated in pre-grant this opposition is not at all relevant. Therefore, you counter it, and then both opponent and innovator are called together for discussion, arguing among themselves, and whosoever satisfies the controller wins. Patent gets granted or rejected. This is the standard patent prosecution process in India. And India patent filing has to be either directly by the applicant, the innovator, or through a patent agent. Any Nick, Tom, Henry cannot submit application as a representative of an innovator. One has to be registered patent agent with the patent authorities. Only they can represent a patent applicant and innovator to the patent office. With this, I will, because this is a topic one can carry on unabated for hours and hours and hours together. But looking at the time is precious, I don't want to rather carrying on unabated. And let us have some time for question answers also, which will give an opportunity to me also to enrich my knowledge domain on this aspect. Thank you very, very much for patient hearing. And I was rather worrying that since 4 o'clock is after lunch time, whether my talk proves to be a sleep-inducing or awakening tablet. You are the best person to tell me. Thank you very much at all. And it's open for question if there is any.
Hello, sir.
Thank you, Dr.
Hello, sir.
Saigal. Thank you so much for your very, very informative session. Now, yeah, there's a time for the question answer session. Yeah, participants can ask the questions.
Hello, sir. Myself,
Yes,
Parag Marathe.
Yeah.
Correct, sir.
I have a question that if
You wanted
suppose
to
I
ask a question.
complete specification,
Yeah.
it is necessary to pay the publication fee, or it going to automatically publish on the their website?
No, for provisional application, you have to file the only original fee. You do not have to file the examination fee. Because let me tell you,
Sir,
there are...
I am asking about the publication fee.
No, you don't have to file. For provisional, you don't have to pay publication fee.
No, I filed the complete specification.
For that, no. I tell you, publication fee is optional, not compulsory.
Okay, then how after how many months it
18 months is
automatically get?
18 months is the standard time of publication. 18 months.
Okay, sir. Thank you, sir.
Because the Form 9, which I told you for publication one body, that is a optional, not compulsory.
Okay, sir. Thank you, sir.
Yeah.
Any other question?
Hello, sir.
Yeah.
Good evening, sir.
Good evening.
Thank you, sir. Thank you for informative and very nice presentation, sir. Sir, I have a doubt. What is the
Yeah.
dependent innovation and independent innovation, sir? Dependent
I tell you, these are not the innovation. These are the claims.
claims, dependent claim and independent.
Yeah. Because independent claim is your main invention scope,
Okay.
and there are limitations to that because one tries to get the broadest possible claim,
Okay.
and then that broadest possibility has some limitations to that,
Okay.
and those limitations are there in the form of dependent claims. For example, let me cite an example to you.
Okay, sir.
Let me cite an example to you. I say a chemistry process claim. Process of preparing a molecule of formula A, wherein reactant A is reacted with reactant B in the presence of a base. Base is very broad. Base, as there are thousands of bases in the chemistry. This is an independent claim. Now you put a dependent claim. The process according to claim 1, wherein the base is selected from, you give a number of bases. You got it?
Okay. Okay,
I'm
sir.
giving
Okay,
an
sir.
example so that there's a clear understanding. You got it now?
Yes, sir.
So this is independent and dependent claims.
Yes, sir. Okay, sir. Thank you, sir. Thank you so much, sir.
Yeah.
Very informative section, sir.
Thank you very much. Rather, I hope that that's what I'm telling you, whether it is a sleeping pill or awakening pill.
No, sir. It is not a it is a waking.
Any other question?
Sir, I would like to know why there have been no attempts in amending the Section 3D of the Indian patent law when it is detrimental to the country in a way.
Let me tell you, this is a very, very subjective question. Very, very subjective question. There has been many talks on that, and it is at government level they have to take a call on it, or some committees they have to make it. When you say amendment has to be such which does not give a very free hand to the innovator companies, pharma companies in particular. Particularly, it pertains to the pharma sector. Please note it, health sector, and that is very subjective question. There have been many discussion on that. As I told you, in some cases there has been a grant of patents. That's at the controller level. It is how the matter is argued with the controller. It depends on that. How the matter is argued with the controller during prosecution, and later if it gets taken to the court, then how the matter is argued there. If at all there is an enhanced efficacy and there is a sporting data on that aspect, because there is a one patent which has been granted in respect of the thermostability, and this was not escalated to the court of law. It remained only at the controller level, mind you. Please note it.
So there is a way to bypass the Section 3D in this manner.
There are ways and means. Many people do it. It all depends on case to case, because you have to provide sporting data during prosecution.
Agreed, sir.
It all depends on that.
Thank you, sir.
Okay.
Thank you.
Is there any question? Any question from other participant? Okay, fine. Thank you, sir, very much. Thank you very much for your wonderful session. Now I initially request Sadhvi madam to summarize the session, and then we will move towards the closing remark given by Dr. Dheeraj Magre. Sheetal Patel madam, do you have any question?
Yeah. Sorry for the interruption because mic was not working properly.
Okay, please
Sir, to encourage the girl students, I belongs to an engineering college. and to encourage the girl students to go for their projects to be patented. Is there any special provision for in our Indian constitution, sir, with respect to patent?
I tell you, in respect to the patents, because patent as such, innovation research has to be carried out by the student. There is no bar on that. However, Government of India has got a provision in respect of the financial assistance for, because patent one has to pay a lot of fees. Student is the less, of course, and during prosecution one has to pay fee, and then for maintaining a patent one has to pay a lot of fee. As I told you, it's a tangible asset, but it's not something which one gets for free. One has to maintain. It costs money. And there is a department, Government of India. There is one department. I do not know the details, but there is one who gives financial assistance to the students. Are those who cannot manage acquiring IP because of financial aspects in respect of prosecution. They get benefits from the government as a prosecution fees, filing fee, maintenance fee, likewise.
Okay. Thank you very much, sir. Let me then ask the students to go through such type of provision if they are having specifically.
Yeah, there is a provision by Government of India. There is a provision.
Yeah, specifically, sir, to encourage the girls, to go for such type of innovative projects and this. So in this respect, I'm, facing lots of problems. Because boys are always ready to get it, but how to encourage the girl students specifically?
Let me
So
tell
that was a big challenge for me. Yeah.
I tell you one thing. This Indian Patent Office has got a very good provision. If the innovator is one of the lady, then the patent prosecution is with a greater speed. Vis-a-vis if male is an innovator. That's a fact I'm telling you.
Yes, sir. They are absolutely correct. Thank you very much, sir.
And furthermore, let me tell you, as I started with, which is somehow India is lacking behind in a bigger way, must have a technology landscape of the project on the field where you want to undertake a such project. And looking and considering its applicability to specific industries where you have got a ready buyer for that, for which you do a lot of work and get paid. That is a paramount importance. Creating an IPR may be easy, but monetizing an IPR may not be that easy unless and until this aspect is taken into consideration at the beginning of creating an IPR.
Okay, sir. Yeah, got it.
Okay, sir.
Got
Thank
it.
you
Thank
very
you
much.
very much, sir.
Now this is the time for summary of the session. I request Sadhvi madam to give summary of the session, and then Dr. Dheeraj Magre will be giving the closing remark. Sadhvi madam, please.
Thank you, sir. First of all, good evening to everyone. And I would like to thank our eminent speaker for this session, Dr. C.K. Sehgal. Sir, it was an amazing and very brainstorming session. You briefly gave us an insight about what is intellectual property rights and the history of the intellectual property rights. Then you explained the two kinds of intellectual property, that is industry property and copyright property, and then highlighted the objects of intellectual property and what are the forms of intellectual property rights. You then explained the protected intellectual property and informed about the level of ordinary skill in the art and their factors. Then you also acknowledged us with the origin of IPR patents and what can actually be patented. Then, sir, you gave us a wonderful example of turmeric and also explained that why it cannot be patented, because it is a product of traditional knowledge. Then, sir, you explained the history of patents, patent system timeline, what rights does a patent owner have, who may obtain a patent, life of patents, wherein the utility patents have a life of 20 years and design patents have a life of 14 years, primary requirement for a patent, and briefly explained the Indian patent law and the development of patent law in India. Then you also introduced the IPR Acts and rules in India for patents, industrial designs and trademarks, Indian Patents Act 1970, Indian Obligation to WTO 2005 Amendment, different sections about what is patentable and what is not patentable, the non-patentable inventions in India, anything that is in national interest cannot be put into public domain. Then you also explained the new chemical and new mechanical entity and the section 3D very briefly, and the incremental innovations and their importance in medicine. You then gave us the example of long waves of bioscience and their innovation throughout with the help of the flowchart, new uses for medicines, what is 3D efficacy with a brilliant case study, the use of 3D nimesulide, thermal stability 3D, Gilvec 3D, Merck sitagliptin 3D, level of ordinary skill in the art and factors. Important case studies were given by you, sir. The national product distinguished and also distinguished between the natural product and modified natural product and the claims relating the same. You then explained the patent filling and prosecution and the traditional patent systems. And then lastly, sir, you explained the benefit of the one international application known as the Patent Cooperation Treaty and the patent grant procedure. The overall session was very informative and involving, sir. Thank you so much.
Thank you, Sadhvi madam. Now I request Dr. Dheeraj Magre to give a closing remark.
Yes. Good evening to all of you. So Dr. C.K. Sehgal having oceanic knowledge, really.
Good evening, sir.
Obviously, when he is explaining all these things through the depth of his knowledge, we are coming to know that this person can talk even a day is very less to him. Unfortunately, we have only given 2 hours to him. But really, when he explained the things very thoroughly, by putting up each and every case study, by giving the baseline, okay, and justifying the things really, we can say the fundamental or basic sentence formation only. So I will very give your thanks to the Dr. C.K. Sehgal for such information and insight to paint for the talk and informative learning about from the patenting related things. Really, in IP, in the basic what are the patenting throughout from the history till date, what are the patenting and what are not patenting, all these things covered in the today's talk. We can say that whatever the very first slide you are mentioned over here is patent is a product of the human creation. Is very true sentences you are put it on the slide. So by giving that very well presented importance of the aspects in such a what we can say that in national level workshops such as in the IPR and innovations, which is organized by SPC and REC REWA. So both are organized such a beautiful session for us. I'm thankful to the SPC organizing team also, and Dr. Santosh Rane and his team very well are organized this IPR and innovation related workshop. I am very much thankful, and I also appreciate that all these whatever the sessions is going on till date is very informative. Thanks. Over to you, Dr. Santosh Rane.
Thanks to all of you. Thank you, Dr. Sehgal. We will be having one more session from Dr. Sehgal. He will be participating in the panel discussion as a senior panel member, and we will be enjoying his thought process over the entire IPR world. Yeah, fine. Yep. Thanks to all of you for participation. And
thank you very much for very patient hearing. I look forward to seeing you tomorrow again.
Thanks to everybody. Yes.
Sir, am I audible to you, sir?
Yes, sir. Yes. Yes, sir. You are audible.
Only lawyer has to file patent, sir.
Hello?
Not necessarily.
Is it only lawyer has to file patent, sir?
No, it's not only that. I told you, patent can be filed by an innovator directly with the patent office. Else, patent agent. Because every lawyer cannot do it. a lawyer has to be a patent agent registered with the Indian Patent Office. Indian Patent Office conducts an examination periodically. It was held last year. And in that examination, one has to go through that examination. And if one passes an examination, then only one can become a patent agent, not otherwise.
Oh,
Patent
whether
agent has got to register a-
whether he is a lawyer or otherwise, he has to pass
whether
that
he's a lawyer
patent
or not a
examination and
No,
become
to be a
patent
patent
agent.
agent, one doesn't have to be a lawyer.
Okay.
It is not necessary that one has to be a lawyer to be a patent agent. Patent agent can be anybody.
Okay. Thank you, sir. Thank you very much.
Okay, thanks to everybody. We will close the session. Thanks to all the participants for active participation and intelligent questions. Bye-bye. Good evening. Bye-bye.
Bye. Thank you very much.
Thank you. Thank
Bye,
you.
sir. We will close.
Thank you, sir.